Ladies and gentlemen of the media, good afternoon, members of the listening and viewing public. Two recent judgments have been delivered by the Judicial Committee of the Privy Council concerning the Estate Management Development Company Limited and various contractors and individuals, which have attracted a considerable amount of media attention and have been the subject of comment by Mr. Ramesh Lawrence Maraj, Senior Counsel, and by Member of Parliament and former Line Minister for the EMBD, the Honorable Dr. Reginald Munilal. The first matter, High Court Action number 01415 of 2017, involves a claim between the EMBD and different contractor companies and individuals, in which the EMBD is seeking to recover in excess of $300 million, which were paid out by the EMBD in the months immediately preceding the September 7th, 2015 general election, which I shall hereafter refer to as the cartel claim. The second matter involves a claim by the company, Junior Samy Contractors Limited, against the EMBD with respect to monies allegedly due by the EMBD to the Junior Samy Company under a contract awarded to that company by the EMBD in February 2015. I shall refer to that matter as the Junior Samy Company matter. This claim has now been successfully affirmed by the Privy Council yesterday, 29th October 2024. I issued a media statement on the 22nd of October 2024 with respect to the order of the Privy Council of the 8th of October 2024 in the cartel claim, which now allows the trial of EMBD's claim to commence. The significance of the order of the Privy Council in the cartel claim is that the defendant contractors and individuals must now put in their defenses by the 6th of November on hold since December 2017, and that trial can now proceed. Respecting as I do that the cartel claim is a trial which is about to start, I have so far restrained myself from commenting on the claim and the facts in support of the EMBD's claim in that matter, given sub judice principles. However, in the context of the comments which have been made on those two matters, and particularly since yesterday and the ensuing media coverage, I consider it prudent today to make this further statement to have the record stated correctly. Context is always important. The context which is relevant and common to both matters is that on the 7th of September 2015, the government of the Republic of Trinidad and Tobago changed from a People's Partnership government to that of the People's National Movement, now in its 10th year of office, and in which I have the privilege to serve as Attorney General. The contextual significance of that election date, 7th September 2015, is that in large measure, all the very lucrative contracts which were awarded by the EMBD in those two matters were awarded in the months leading up to that general election. The line minister of the EMBD in that period of awards was the Honorable Dr. Reginald Munilal. I beg his pardon. I am constrained today to make the statements that I now do with respect to those two matters, particularly for the reason that since the delivery of the Privy Council's order on the 8th of October, under which he now contemplates the witness box for his trial, the Honorable Dr. Munilal has been issuing statements in the public. In particular, since the judgment yesterday, he has been conflating, and I emphasize the word conflating, mixing up the two matters in a condemnation of the legitimate and justifiable attempts by this government to recover monies in excess of $300 million, which were paid out by the EMBD, allegedly wrongly and fraudulently, in the cartel claim when he was the EMBD's line minister. It is important that the public understands that because of the vast expenditure of money paid out by the EMBD prior to that general election, On the change of government on the 7th of September 2015, the EMBD commissioned a significant process of audits and expert investigation and reports to verify the legitimacy of the expenditure of taxpayers' money. In the cartel claim, I do not propose to discuss nor comment on the alleged facts which are still to be interrogated at the trial, which will now finally commence after being on hold since 2017. I will, however, read from certain paragraphs of the judgment of Mr. Justice James Abood, which was given on the 6th of August 2020. I will read from paragraphs 6, 7, 8, 13, and 14 of the judgment of Mr. Justice Abood. And may I say that I have asked my team to make copies of the judgments to which I will refer in this media statement and leave them with you members of the media so that you can verify the accuracy of that which I am going to refer to in those judgments of the High Court and the Privy Council. So if I may start with paragraph 6 of the judgment of Mr. Justice James Abood, delivered on the 6th of August 2020. Quote, on the 12th of October 2017, EMBD filed a defense and counterclaim to each of the claims. In brief, EMBD alleges that the three claimants colluded among themselves and with the other defendants in the related action and were involved in an unlawful means conspiracy which led to the award of 12 contracts and the payment of over $300 million for defective and overpriced work. It is said that the cartel ensured that specific companies were awarded specific contracts at inflated amounts and received monies that were not due for defective and irremediable and/or useless works. Paragraph 7. By way of a general summary, the claims are grounded in A, the tort of unlawful means conspiracy on the part of the three claimants and the other parties named in the related action, namely the three EMBD contractors, Rudal Munilal, a former government minister, and three senior EMBD officers who held offices prior to the change of government in September 2015. B, breach of fiduciary duty on the part of Dr. Munilal and the three senior officers of EMBD. C, knowing receipt and dishonest assistance. D, declarations that the alleged contracts are void or otherwise non-existent as a matter of agency law. E, an account of all the monies paid to the three claimants, together amounting to over $101 million. In the case of a company named, EMBD added, and person named, the principal of that company as a second defendant to the counterclaim and made an additional claim in bribery against him and the named person. The names are there. When you read the judgment, I will leave it to you to determine how much of it you publish. Paragraph 8. EMBD is what is called, quote, a special purpose company, unquote, in Trinidad and Tobago parlance. It is incorporated under the Companies Act. It is a state-owned entity with a politically appointed board. And I skip one line. It goes on to say in paragraph 8, at the material time, EMBD reported to the Ministry of Housing and Urban Development, of which Dr. Munilal was the then minister. In our vernacular, he is called, quote, the line minister, unquote. Amongst other things, EMBD is mandated to sublease agricultural state lands, manage and develop lands formerly owned by Carly 1975 Limited, and to develop residential sites on those lands. So that's paragraphs 6, 7, and 8. I go next, ladies and gentlemen, to paragraph 13 of the judgment of Mr. Justice James Abood, as he then was. He is now Mr. Justice James Abood, Justice of Appeal. Paragraph 13. As said earlier, the first defendant, Dr. Munilal, was the line minister. EMBD reported to him or his ministry, and he in turn reported to the cabinet. The second defendant, name called, was at all material times EMBD's acting chief executive officer, CEO, and later, during the period when it is alleged that the conspiracy was in full-blown operation, he was appointed its CEO. At all material times, the third defendant, name called, was EMBD's divisional manager projects, and for the period 27th July to 7th August 2015, its acting CEO. The fourth defendant, name called, was EMBD's resident engineer. All four of these defendants are alleged to be part of the cartel arrangements. As will be examined in greater detail below, it is EMBD's pleaded case that Dr. Munilal operated like EMBD's virtual puppeteer, controlling and directing Mr. name called to award the EMBD contracts, or some of them, and directing the delivery of EMBD checks to him personally for onward delivery to the EMBD contractors, excluding and companies excluded. And there are six more lines to paragraph 13 that I'm not going to read, but you will have the judgment. You can review it in your leisure. Paragraph 14. It is the EMBD's case that the claimants in the consolidated action and the two contractors in the related actions enriched themselves by procuring EMBD contracts, certifications, and payments by way of collusion between themselves and Dr. Munilal and Messrs, and three names are called, so that through unlawful means and in breach of the fiduciary duties owed to EMBD by its officers and those owed to the Republic by Dr. Rudal Munilal, specific companies were awarded specific contracts at greatly inflated contract prices and received excessive and unjustified payments for works that were incomplete or defective or both. End of quote, paragraph 14. Those are the paragraphs of Justice James Aboud's judgment that I draw to your attention, and as I have said, I will be leaving copies of that judgment for you members of the media. I will say nothing further on that. I will allow the trial to proceed when the defenses are put in on the 6th of November, and allow our courts to make their determinations in due course with respect to the claim of EMBD to recover over $300 million of taxpayers' money. It is very important, ladies and gentlemen, to distinguish the cartel claim from the second matter, the second judgment that was delivered yesterday, also involving the EMBD. I should make it clear that nothing pronounced on by way of the Privy Council in that matter involving the EMBD and Mr. Junior Samy's company affects the merits of the case that the EMBD is going to trial on in the cartel claim against Dr. Munilal or any of the other defendants in that matter. Mr. Ramesh Lawrence Maraj, Senior Counsel, a former respected Attorney General, appeared for Mr. Junior Samy and his group of companies in that second matter, the Junior Samy matter. He has held a press conference, which I have listened to. I congratulate Mr. Maharaj and Mr. Junior Samy on their victory in the courts. Due process has taken its course. I take the trouble, however, to highlight 3 points which were not sufficiently addressed by Mr. Maharaj in his press conference yesterday with reference to the 29th October Privy Council judgment in the Junior Samy matter. 1. Paragraph 9 of that judgment refers to the fact that, if I might just get that judgment out, attorneys for the EMBD conceded the fraudulent claim against Mr. Junior Samy. Let me just get my papers properly organized here. So if you look at paragraph 9 of that particular judgment, you will see the passage in which the Privy Council records the fact that attorneys representing the EMBD in that matter conceded. This is what is said in the last 3 lines of the EMBD judgment in the Junior Samy matter. This is not a sufficient basis on which to allege fraud. Thus, counsel on behalf of the employer that is to say EMBD, correctly conceded during the hearing before the board that the defense should not be read as pleading a positive case of fraud. So to the extent that Mr. Munilal is seeking to combine his case, which is coming for trial, with the case against Mr. Junior Samy, and to rely on anything said by the Privy Council in the Junior Samy judgment, which was delivered yesterday involving a case of fraud, it will not assist him when he takes the witness box. It was prudent, in my respectful view, for the EMBD, against the background of the rush to award contracts leading up to the general election in September 2015, to have thoroughly audited all claims at the point at which the audit revealed that there was insufficient evidence to support the allegations of fraud, and that was in due course properly conceded. We remember that what I had said at the earlier stage of this media statement, this media address, is that after the general election, when the governments changed, the EMBD commissioned a number of audits and expert investigations because they were very concerned to ascertain the state of all of the contracts which had been awarded. Among the contracts which had been awarded was a contract to the Junior Samy group of companies, but in due course, as counsel for the for EMBD has conceded, that part of the case was not specified as being fraud and was conceded at the Privy Council. The second point of difference that I make between what I say here today and what is in the record as having been said by my learned friend, Mr. Ramesh Maharaj, he correctly pointed out that the Privy Council judgment is very important for its pronouncements with respect to FIDIC contracts. FIDIC contracts are specialized contractor contracts that govern the construction industry. And he is correct that there is significant statements in that judgment that will guide contractors in Trinidad and Tobago going forward on the proper regulation and interpretation of FIDIC contracts. I noticed at the end of his press conference yesterday, he remarked that his client, Mr. Junior Samy, has committed to hosting a working conference either towards the end of this year or into early next year, in which he, Mr. Junior Samy, is going to fund a conference course for contractors to sit down and to listen to experts in the law, including the legal team who represented Mr. Junior Samy before the Privy Council, so that they can explain to contractors in Trinidad and Tobago the significance and meaning and proper construction of FIDIC contracts. And I applaud that. I think that it is our civic duty as citizens all to contribute to our understanding of the operating instruments by which we do business with each other. As Attorney General, I applaud that, and I offer here publicly to Mr. Ramesh Maharaj any assistance that he might wish to call on me to give in order to assist him in that conference. I say all of that, however, to make this distinguishing point between myself and Mr. Maharaj's comments yesterday with respect to the other significance of the judgment of the Privy Council in the Junior Samy matter. And I'm leaving copies of it with you all. I saw in his press conference, he said he was sending it to the media, but I've had hard copies made and I will leave them to you. I ask you all to read paragraphs 53 to 89 of that judgment. 36 paragraphs. A very significant and difficult point was interrogated by the Privy Council, brought to the Privy Council by the EMBD in the appeal that was dismissed yesterday. And that very significant point had to do with the construction, the proper construction of Section 32, subsection 7 of our Supreme Court of Judicature Act, and a number of documents that were before the courts of Trinidad and Tobago and the Privy Council on the simple question, and Mr. Maharaj did deal with the fact that the Junior Samy group of companies had borrowed a significant sum of money from the Answer Merchant Bank. And as collateral for the loan that they took from the Answer Merchant Bank, they gave a charge to the Answer Merchant Bank over the assets of the Junior Samy group of companies. And one of the points that was taken by the EMBD all the way to the Privy Council was that the quality of that charge was what is called an absolute charge. Read Section 23, subsection 7 of the Supreme Court of Judicature Act, and you will understand what is meant by an absolute charge. It would mean that the Answer Merchant Bank would step into the shoes of Junior Samy. They would have taken over the entire responsibility for the debt, and therefore, if anybody was to have sued the EMBD to recover the debt, it should have been the Answer Merchant Bank and not Junior Samy. And therefore, the point legitimately that was taken by the EMBD in its defense to the Junior Samy claim is that you, Mr. Junior Samy group of companies, are the wrong party to bring this claim against us. It should have been brought by the Answer Merchant Bank. And this is what the Privy Council said at paragraph 63. The relevant instruments in this case, which required to be construed as a rule or the factor in agreement of the assignment of receivables and the notice of assignment, the true construction of these documents is not straightforward, as they lack coherence and are not well drafted. And there are several indicators that the assignment was intended to take effect as an absolute assignment, but there are other several indicators that the assignment was by way of charge only. The Privy Council spent 36 paragraphs examining this issue before it finally construed that the Section 23(7), as applied to those documents, did not constitute an absolute charge, and therefore Junior Samy could properly have brought the case against the Privy Council. That was what is known to us lawyers and what is accepted by any common sense person as a strong, arguable case. And the EMBD had every right to take that point all the way to the Privy Council and to ask for a ruling on it. So I make that second distinction between myself and my good friend, learned friend, Mr. Maraj, to make the point that the case was not only about the FIDIC contract, it was about another very important issue which the Privy Council spent 36 paragraphs ruling on. And the third point that I want to make, which was not mentioned by Mr. Maraj, but which I think is important, and I don't say this to allocate any blame or responsibility. I have great respect for Ramesh Lawrence Maraj, but it is a relevant consideration. In the context of that which is being said by persons that the EMBD has wasted taxpayers' money in defending this case, which I reject, for the public to understand that as early as the 17th of August 2020, the attorneys representing the EMBD paid part of the disputed sum of money to the tune of $87 million to Mr. Samy's attorneys. So since the 17th of August 2020, attorneys representing the EMBD paid $87 million of Junior Samy's claim to his attorneys, and on that day paid a further sum of $37,424,772.80 into court to be put into an interest-bearing account pending the determination of these appeals. So this was not a frivolous appeal by the EMBD. This was a serious appeal. There were serious issues of law to be addressed, but in the interest of fairness and prudence, they paid to Junior Samy what they conceded was his right, and they paid the disputed balance into court to be put into an interest-bearing account so that at the end of the day, when the case was determined, that money, that $37 million figure would be allocated to the rightful owner. As of yesterday's date, that money, with the interest that it has earned, will now be paid over from the court, the Supreme Court, to Mr. Junior Samy. And I emphasize that to make the point that the EMBD has been prudent and responsible and has not wasted taxpayers' money, as certain persons, who I shall not continue to name, because I have to call them honorable in pursuing these matters. In the pursuit of the cartel claim, which the defendants, Dr. Munilal included, are now ordered to put in their defenses, the EMBD will continue to pursue its claim to recover in excess of $300 million for the taxpayers of this country. And I want to go on record to thank the chairman, Mr. Ronnie Mohammed, and all the attorneys who have so far labored long and hard in the vineyard and will continue to do so to bring home that $300 million claim for the taxpayers of this country. Thank you, and I will now take questions.
IAG, good afternoon. Derek Atcham from Guardian Media Limited here. I think you touched on the point towards the end, but both Mr. Mirage and Hugh must not be named. It would have raised concerns over the amount of legal costs that EMBD and ultimately the state would incur in pursuing claims and defending them. Is the situation where your office has to decide based on the nature of the claim, how much is at stake, the strength and arguability of the case that will determine the number of senior counsels, or if King's Counsel will be required for the case? Because I think what they were alleging is the legal team was so large, and to pursue this, I don't think there was nuance in terms of the sense of why such a legal team would be needed to defend and pursue complex matters such as these.
Well, I'm not sure, Mr. Achong, exactly what you're asking me. Are you asking me whether I support the retaining of attorneys by the EMBD to defend the claim against Mr. Junior Samy? Are you asking me whether I support the retaining of attorneys to pursue the cartel claim to recover $300 million from Dr. Rudilal, Munilal, and others? What exactly are you asking me?
What I'm asking is, I think what they are alleging is that, you don't need such a powerful team for these matters because it will incur costs inevitably.
Yeah.
Yeah, so I don't know if you
well, it's always, so okay, I understand the question. It's always a judgment call on the part of any client, and in certain cases, I am the client as Attorney General. In other cases, the EMBD is the client. In this case, the EMBD was actually the one who retained attorneys, and in one other case, I was the Attorney General who retained attorneys. And in fact, it would have been my predecessor because these cases have been around before I took office. But always there will be a judgment call on the part of the client as to the complexity of the case, the significance of the case in the public interest, where it is public law litigation or litigation that affects the taxpayers. And among the things that will have to be looked at, and I think Mr. Mirage would accept this, the FIDIC claims are never straightforward claims. They are among the more complex cases, and on the particular issue that I touched on, which is dealt with from paragraphs 53 to 89 of the judgment of the Privy Council in the Junior Samy judgment yesterday, that was a very involved argument that the Privy Council spent 36 paragraphs distilling before they were able to come to their conclusion. So my ultimate answer to your question is, it is always a judgment call on the seniority and the number of lawyers that you will retain to defend or to advance a particular case, and it is expected, and I certainly can stand proud on this, that the judgment call to select the attorneys will be a responsible one.
My final question is both these two cases that you would have spoken about this afternoon, mutually exclusive, as you pointed out, that the facts are different, the parties are different, totally they're not connected as was being alleged in the public domain. Both deals with contracts being awarded for mega projects and projects in general. Do you think that with the moves taken by your government to implement procurement regulation, would help assist and prevent some of this litigation going forward? I mean, we have already seen that the procurement regulator tribunal would have weighed in on a contract. Do you think that this will kind of help sift through and prevent such costly litigation going forward?
Well, let me put it in the specific context of the cartel claim. And the cartel claim is a claim that is now going to trial. Defense was due in December 2017, and it's taken us this long to get the Privy Council to order them to put in their defenses. In that claim, the procurement legislation would certainly, if it had been enforced at the time, would certainly have introduced a regulatory scheme by which, to use the language of Mr. Justice James Abood, Dr. Rudal Munilal would not have been allowed to operate as a virtual puppeteer, picking the persons who would do the contracts and for whose benefit or otherwise he would receive checks.
Mr. Armour, Gregory McBurney from the Trinidad Newsday. My final question is my only question is a rather simple one. I'm guessing no client goes into a matter anticipating that they would lose. That being said, though, how confident
that client would be a fool.
How confident are you of success in the cartel case?
Well, Mr. McBurney, as I've said, I don't want to comment on the case, but what I would say with confidence, and I have seen the documentation, I know that the EMBD not only did a significant audit, but they have amassed a significant amount of expert evidence, which is now going to be presented to the courts. In fact, it was that expert evidence, partly which persuaded the High Court judge, the Court of Appeal judges, and the Privy Council judges to dismiss the case again, the claim brought by the contractors to say that this case couldn't succeed in a trial. They looked at the case as pleaded, the references to the expert evidence, and said this is a strong arguable case, it must proceed, and defendants, please put in your defenses. That's it. I think, thank you all very much, gentlemen and ladies. I am very happy to be among my good friends of the media once again. I don't often find myself speaking with the media, but when I do, I always find it a pleasure. Thank you all very much.